ಹಲೋ ಅಡ್ವೊಕೇಟ್ ಸ್ವಾತಿ ಚಾನೆಲ್ಗೆ ಸ್ವಾಗತ. ನಾನು ಸ್ವಾತಿ. ಇವತ್ತಿನ ವಿಡಿಯೋ ನಮ್ಮ ಹೊಸ ಮಾಕ್ ಟೆಸ್ಟ್ ಸಬ್ಜೆಕ್ಟ್ ಸ್ಪೆಸಿಫಿಕ್ ಪೇಪರ್. ಸೊ ಇವತ್ತಿನ ಮಾಕ್ ಟೆಸ್ಟ್ ಅಲ್ಲಿ ನಾವು ಇಂಡಿಯನ್ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ ನ MCQs ಸಾಲ್ವ್ ಮಾಡೋಣ. ಇದು ಕಂಪ್ಲೀಟ್ ಪೇಪರ್ ನಿಮಗೆ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ MCQs ಬಗ್ಗೆ ಆಗಿರುತ್ತೆ. ಸೊ ಹಾಗಾಗಿ ವಿಡಿಯೋನ ಕಂಪ್ಲೀಟ್ ಸ್ಟಾರ್ಟಿಂಗ್ ಇಂದ ಎಂಡಿಂಗ್ ತನಕ ನೋಡಿ. ಹಾಗೆ ಇಂಡಿಯನ್ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ ಇಂದ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ನಿಮಗೆ ಎಕ್ಸಾಮ್ ಪ್ರಿಲಿಮ್ಸ್ ಅಲ್ಲಿ 8 to 10 MCQs ಖಂಡಿತ ಬರುತ್ತೆ. ಸೊ 8 to 10 MCQs ಅಂತಂದ್ರೆ ತುಂಬಾ ಇಂಪಾರ್ಟೆಂಟ್ ಆಗಿರುವಂತ ಪೋರ್ಷನ್. ಅಂಡ್ ಇನ್ನೊಂದು ಈ 8 to 10 MCQ ಪೋರ್ಷನ್ ಎಂದ್ರೆ ತುಂಬಾ ಈಸಿಯಾಗೂ ಇರುತ್ತೆ. ಬಿಕಾಸ್ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ ಕೆಲವೊಬ್ಬರಿಗೆ ಕಷ್ಟನೂ ಅನ್ನಿಸ್ಬಹುದು, ಬಟ್ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ ವೆನ್ ಅಂಡರ್ಸ್ಟುಡ್ ಕಂಪ್ಲೀಟ್ಲಿ ದಿಸ್ ಇಸ್ ವೆರಿ ಈಸಿ ಸಬ್ಜೆಕ್ಟ್. ಸೊ ಹಾಗಾಗಿ ಮಾರ್ಕ್ಸ್ ಇದರಲ್ಲಿ ಕಳ್ಕೊಳ್ಳೋದಕ್ಕೆ ಹೋಗಬೇಡಿ. ತುಂಬ ಈಸಿ ಆಗಿರುವಂಥ ಸಬ್ಜೆಕ್ಟ್. ಆ್ಯಂಡ್ ಹಾಗೇನೆ ಎಕ್ಸಾಮ್ ಪೇಪರ್ ಪ್ರತಿ ಬೇರೆ ಸಬ್ಜೆಕ್ಟ್ ರೀತಿ ಇದನ್ನು ಸಹ ಫ್ಯಾಕ್ಚುಯಲ್ ಆಗಿರುತ್ತೆ, ಸೆಕ್ಷನ್ ಬೇಸ್ಡ್ ಆಗಿರುತ್ತೆ. ಸೊ ಸೆಕ್ಷನ್ ಬೇಸ್ಡ್ ಆದಾಗ ಇಂಪಾರ್ಟೆಂಟ್ ಏನು, ನಮಗೆ ಆ ಸೆಕ್ಷನ್ ನಂಬರ್ಸ್ ಹಾಗೂ ಸೆಕ್ಷನ್ ಹೆಡ್ ಏನು ಅನ್ನೋದನ್ನ ತಿಳ್ಕೋಬೇಕು. ಅದನ್ನ ನೀವು ಚೆನ್ನಾಗಿ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. ಕಾನ್ಸೆಪ್ಟ್ನ ಸೆಕ್ಷನ್ ನಂಬರ್ಸ್ ಏನಿದೆ ಅದ್ರ ಜೊತೆ ಆ ಕಾನ್ಸೆಪ್ಟ್ನ ಅರ್ಥ ಮಾಡ್ಕೊಂಡಷ್ಟು ರಿವೈಸ್ ಮಾಡಿದಷ್ಟು ಈಸಿ ಆಗುತ್ತೆ. ಸೊ ಕಷ್ಟ ಅನ್ನುವಂಥ ಸಬ್ಜೆಕ್ಟ್ ಏನಲ್ಲ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್. ಸೊ ಹಾಗಾಗಿ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ ಇಂದ ಬರುವಂಥ ಅಷ್ಟು ಕ್ವೆಶನ್ಸ್ ಇಂಪಾರ್ಟೆಂಟ್ ಆಗಿರುತ್ತೆ. ಆ್ಯಂಡ್ ಯಾವುದೇ ರೀತಿ ಈ 10 ಮಾರ್ಕ್ಸ್ ಏನಿದೆ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ದು ಅದನ್ನ ಕಳ್ಕೊಳ್ಳೋದಕ್ಕೆ ಹೋಗಬೇಡಿ. ಸೊ ಈ ವಿಡಿಯೋನ ಸ್ಟಾರ್ಟಿಂಗ್ ಇಂದ ಎಂಡಿಂಗ್ ತನಕ ಕಂಪ್ಲೀಟ್ ಆಗಿ ನೋಡಿ. ಆ್ಯಂಡ್ ನಮ್ಮ ಆಲ್ರೆಡಿ ಈಗ ಏನು ಪೋಸ್ಟ್ ಆಗಿದೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್, CPC ಮತ್ತೆ CRPC ಹಾಗೂ ಒಂದು ಕಾಂಪ್ರಿಹೆನ್ಸಿವ್ ಪೇಪರ್, ಅದನ್ನ ನೀವು ಕಂಪ್ಲೀಟ್ ಆಗಿ ನೋಡ್ತಿದ್ದೀರಿ. ಸೊ ತುಂಬಾ ಖುಷಿ ಆಗುತ್ತೆ ನಿಮ್ಮ ರೆಸ್ಪಾನ್ಸ್ ಇಂದ. ಆದಷ್ಟು ಜಾಸ್ತಿ ಅದನ್ನ ರಿಪೀಟ್ ಮಾಡಿ, ನೀವೇ ಏನು ಕಮೆಂಟ್ ಮಾಡಿ, ಕಮೆಂಟ್ ಮುಖಾಂತರ ತಿಳಿಸ್ತೀರಿ ದಟ್ ಕ್ವೆಶನ್ ಪೇಪರ್ ತುಂಬ ನಮಗೆ ಹೆಲ್ಪ್ಫುಲ್ ಆಗ್ತಿದೆ, ಇನ್ನಷ್ಟು ಕ್ವೆಶನ್ ಪೇಪರ್ಸ್ನ ರೆಡಿ ಮಾಡಿ ಅಂತ. ಸೊ ದಿಸ್ ಇಸ್ ಆಲ್. ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್. ತುಂಬ ಅಪ್ರಿಷಿಯೇಟ್ ಮಾಡ್ತಿದ್ದೀರಿ. ಆ್ಯಂಡ್ ಇದೇ ರೀತಿ ನಮ್ಮ ಎಕ್ಸಾಮ್ ತನಕನೂ ನಿಮಗೆ ಮಾಕ್ ಟೆಸ್ಟ್ ವಿಡಿಯೋಸ್ ಎಲ್ಲ ಮೇಜರ್ ಸಬ್ಜೆಕ್ಟ್ದು ಸಿಗುತ್ತೆ. ಸೊ ಹಾಗಾಗಿ ನಿಮ್ಮ ತಯಾರಿ ಒಳ್ಳೆ ರೀತಿಯಲ್ಲಿ ಇಡಿ. ಇನ್ನೊಂದು 3-4 ಡೇಸ್ ಅಷ್ಟೇ ನಿಮ್ಮ ಎಕ್ಸಾಮಿಗೆ ಟೈಮ್ ಉಳಿದಿರೋದು. ಸೊ ಹಾಗಾಗಿ ರಿವಿಷನ್ ಇಂಪಾರ್ಟೆಂಟ್. ಪ್ರತಿ ವಿಡಿಯೋಲ್ಲೂ ಹೇಳ್ತೀನಿ ಆದಷ್ಟು ಜಾಸ್ತಿ ರಿವೈಸ್ ಮಾಡಿ ಅಂತ. ಸೊ ಹಾಗಾಗಿ ರಿವಿಷನ್ ಆ್ಯಂಡ್ MCQsನ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋದು ಬಿಡಬೇಡಿ. ಈಗ ಇನ್ನೂ ಜಾಸ್ತಿ ಮಾಡ್ಕೊಳ್ಳಿ ಈ ಒಂದು ರಿವಿಷನ್ ಹಾಗೂ ಪ್ರಾಕ್ಟೀಸ್ MCQsನ ಸಾಲ್ವ್ ಮಾಡುವಂಥದ್ದು. ಹಾಗೆ ನಮ್ಮ ಮೇನ್ಸ್ ಬ್ಯಾಚ್ ಏನು ಸ್ಟಾರ್ಟ್ ಆಗಲಿದೆ, ತುಂಬ ಬೇಗ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ ನಿಮ್ಮ ಒಂದು ಈ ಪ್ರಿಲಿಮ್ಸ್ ಮುಗಿದ ತಕ್ಷಣನೇ. ಸೊ ಹಾಗಾಗಿ ನಾವು ಅದಕ್ಕೂ ಸಹ ಕಾತರದಿಂದ ಕಾಯ್ತಿದ್ದೀವಿ. ಸೊ ನಿಮಗೆ ಇನ್ನೇನಾದರೂ ಇನ್ಫಾರ್ಮೇಷನ್ ಬೇಕಿದ್ರೆ ಮೇನ್ಸ್ ಬ್ಯಾಚ್ ಸಂಬಂಧಪಟ್ಟ ಹಾಗೆ ನೀವು ಈ ನಂಬರ್ಗೆ ಸಂಪರ್ಕಿಸಬಹುದು, 9650849915. ಆ್ಯಂಡ್ ಫಸ್ಟ್ ಟೈಮ್ ವಿಡಿಯೋ ನೋಡ್ತಿದ್ದೀರಿ ನೀವು ಅನ್ನೋದಾದರೆ ನಿಮಗೆ ತಿಳಿಸೋದಕ್ಕೆ ಇಷ್ಟ ಆಗುತ್ತೆ ದಟ್ ನಮ್ಮ ಹೊಸ ಮೇನ್ಸ್ ಬ್ಯಾಚ್ ಸ್ಟಾರ್ಟ್ ಆಗ್ತಿದೆ. ಸೊ ಮೇನ್ಸ್ ಬ್ಯಾಚ್ ನಿಮಗೆ ಕಂಪ್ಲೀಟ್ ನಿಮ್ಮ 4 ಪೇಪರ್ನ ಫೋಕಸ್ ಮಾಡ್ತೀವಿ. ಆ್ಯಂಡ್ ನಿಮ್ಮ 4 ಪೇಪರ್ನ ಪ್ರಾಕ್ಟೀಸ್ 100% ಮಾಡೋಣ ಈ ಒಂದು ಮೇನ್ಸ್ ಬ್ಯಾಚಲ್ಲಿ. ನಮ್ಮ ಪ್ರೈಮ್ ಫೋಕಸ್ ನಿಮ್ಮ ಪ್ರಾಕ್ಟೀಸ್ ಮೇಲೆ ಆಗಿರುತ್ತೆ. ಆ್ಯಂಡ್ ನಿಮ್ಮ ಜಡ್ಜ್ಮೆಂಟ್ ರೈಟಿಂಗ್ ಸ್ಕಿಲ್ಸ್, ಆನ್ಸರ್ ರೈಟಿಂಗ್ ಸ್ಕಿಲ್ಸ್ ಇದರ ಬಗ್ಗೆ ತಿಳಿಸೋದು, ಇದರಲ್ಲಿ ನಿಮಗೆ ಆದಷ್ಟು ಜಾಸ್ತಿ ಹೆಚ್ಚಾಗಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿಸೋದೇ ಆಗಿರುತ್ತೆ. ಸೊ ಹಾಗಾಗಿ ಆ್ಯಂಡ್ ನಿಮಗೆ ಅಷ್ಟು ಮೇನ್ಸ್ ಬಗ್ಗೆ ಇರುವಂಥ ಕ್ವೆಶನ್ಸ್ ಕ್ಲಾರಿಟಿ ಏನು ಬೇಕು ಪ್ರಿಲಿಮ್ಸ್ ಬ್ಯಾಚಲ್ಲಿ ಆಲ್ರೆಡಿ ನೀವು ನೋಡಿದ್ದೀರಿ. ನಾನು ಹೇಗೆ ಹೇಳ್ಕೊಡ್ತೀನಿ, ಕ್ಲಾಸಸ್ ಹೇಗಿರುತ್ತೆ ಅಂತ. ಆ್ಯಂಡ್ ನಮ್ಮ ಫೀಡ್ಬ್ಯಾಕ್ ಸೀರೀಸ್ ಏನು ನಡೀತಿದೆ, ತುಂಬ ಸ್ಟೂಡೆಂಟ್ಸ್ ಅಷ್ಟು ಒಳ್ಳೆ ಫೀಡ್ಬ್ಯಾಕ್ಸ್ನ ಕೊಡ್ತಿದ್ದಾರೆ. ಸೊ ಹಾಗಾಗಿ ನನಗೂ ಸಹ ಏನಷ್ಟು ಮೋಟಿವೇಶನ್, ಎಂಥೂಸಿಯಾಸಮ್ ಇನ್ನಷ್ಟು ಜಾಸ್ತಿ ಇದೆ ಮೇನ್ಸ್ ಬ್ಯಾಚ್ ಕಂಡಕ್ಟ್ ಮಾಡೋದಕ್ಕೆ. ಬಿಕಾಸ್ ಪ್ರಿಲಿಮ್ಸ್ಗಿಂತ ಒಂದು ಹೆಜ್ಜೆ ಮುಂದೆ ಮೇನ್ಸ್ ಬ್ಯಾಚ್ ಅಂತಂದರೆ ಸ್ವಲ್ಪ ಇನ್ನಷ್ಟು ಸೀರಿಯಸ್ ಆಗಿ ಅರ್ಹರಿರುವಂಥ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ ಯಾರು ನೀವು ಪ್ರಿಲಿಮ್ಸ್ ಪಾಸ್ ಆಗಿದ್ದೀರಿ, ನಿಮಗೋಸ್ಕರ ಇರುವಂಥ ಎಕ್ಸಾಮ್. ಅರ್ಹರಿರುವಂಥ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ ಅಂದರೆ ನೀವು ಈ ವರ್ಷನೇ ಪ್ರಿಲಿಮ್ಸ್ ಪಾಸ್ ಆಗಿ ಮೇನ್ಸ್ ಬರೀಬೇಕಂತ ಇಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಎಕ್ಸಾಮ್ಗೂ ಸಹ ನಿಮ್ಮ ಒಂದು ತಯಾರಿ ಈಗಲಿಂದಾನೇ ಮಾಡ್ಕೊಳ್ಬಹುದು. ಸೊ ಹಾಗಾಗಿ ನೀವು ಈಗಲೇ ಬರೀತಿದ್ದೀರಿ ಎಕ್ಸಾಮ್, ಇದೇ ವರ್ಷ ಬರೆಯೋರಿಗೆ ಮಾತ್ರ ಅಂತ ಇಲ್ಲ ಪ್ರಿಲಿಮ್ಸ್ ಪಾಸ್ ಆದವರಿಗೆ ಮಾತ್ರ ಮೇನ್ಸ್ ಕ್ಲಾಸ್ ಅಂತಲೂ ಏನಿಲ್ಲ. ನಿಮ್ಮ ತಯಾರಿಗೆ ನಾವು ನಿಮಗೆ ಜೊತೆ ಕೊಡೋದಕ್ಕೆ ಸ್ಟಾರ್ಟ್ ಆಗ್ತಿರೋವಂಥ ಬ್ಯಾಚ್. ಸೊ ತುಂಬ ಜನ ಕೇಳ್ತಾರೆ ಏನಂತಂದರೆ, ಜಡ್ಜ್ಮೆಂಟ್ ರೈಟಿಂಗ್ ನಾವು ಕಾಲೇಜಲ್ಲಿ ಇದ್ದಾಗಲೇ ಕಲಿಬಹುದಾ? ಖಂಡಿತ ಕಲಿಬಹುದು. ಜಡ್ಜ್ಮೆಂಟ್ ರೈಟಿಂಗ್ ನಿಮಗೆ ಅದೊಂದು ಸ್ಕಿಲ್ ಆಗಿರುತ್ತೆ, ಆರ್ಟ್ ಅದು. ಸೊ ನೀವು ಕಾಲೇಜಲ್ಲಿ ಓದ್ತಿದ್ದೀರಿ ಅನ್ನೋರು ಸಹ ಜಜ್ಮೆಂಟ್ ರೈಟಿಂಗ್ನ ಕಲಿಬಹುದು. ಇನ್ಫ್ಯಾಕ್ಟ್ ತುಂಬ ಒಳ್ಳೆ ಪ್ರಾಕ್ಟೀಸ್ ಆಗುತ್ತೆ ಇಫ್ ಎಟ್ ಆಲ್ ನೀವು ಜಜ್ಮೆಂಟ್ ರೈಟಿಂಗ್ನ ಈಗಲಿಂದಾನೇ ಕಲ್ತ್ರೆ. ಸೊ ಈ ಥರ ನಿಮಗೆ ಡೌಟೇ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ನೀವು ಜಜ್ಮೆಂಟ್ ರೈಟಿಂಗ್ ತುಂಬ ಒಳ್ಳೆಯ ಒಂದು ಸ್ಕಿಲ್, ಅದು ಯಾವಾಗ ಬೇಕಾದರೂ ಕಲಿಬೋದು. ಕಾಲೇಜಲ್ಲಿ ಇದ್ದಂಗೆ ಕಲಿತೀರಿ ಅಂದರೆ ಇನ್ನೂ ಒಳ್ಳೆಯದು. ಸೊ ಹಾಗಾಗಿ ಪ್ರತಿಯೊಬ್ಬರಿಗೂ ಸಹ ಈ ಬ್ಯಾಚಲ್ಲಿ ಎನ್ರೋಲ್ ಆಗೋದಕ್ಕೆ ಆರಾಮಾಗಿ ಎನ್ರೋಲ್ ಆಗಬಹುದು, ಅವಕಾಶ ಇದೆ. ಎನ್ರೋಲ್ ಆಗಿ ಆ್ಯಂಡ್ ಇದರ ಲಾಭ ಪಡ್ಕೊಳ್ಳಿ. ಸೊ ಕೇವಲ ಇದರ ಫೀಸ್ ಏನಿದೆ, ಅರ್ಲಿ ಬರ್ಡ್ ಆಫರ್ ನಡೀತಿದೆ. 10,000 rupees ಅಂತ ಹೇಳಿದೆ, ಅದು ನಡೀತಿದೆ. ಜೊತೆಗೆ ಬಟ್ ತುಂಬ ಬೇಗ ಇದು ಸೀಟ್ಸ್ ಮುಗಿಯುತ್ತೆ. ಸೊ ಹಾಗಾಗಿ ಅದು ಮುಗಿದ ನಂತರ ಫೀಸ್ ಆ್ಯಸ್ ಯೂಶ್ವಲ್ 12,000 rupees ನಮ್ಮ ಏನು ಮೇನ್ಸ್ ಬ್ಯಾಚ್ಗೆ ಫೀಸ್ ಇದೆ ಫಾರ್ ಆಲ್ ಯೋರ್ 4 subjects ಇನ್ಕ್ಲೂಡಿಂಗ್, ಆ್ಯಂಡ್ 5 full length ಮಾಕ್ ಟೆಸ್ಟ್ ಸಿಗುತ್ತೆ. ಪ್ಲಸ್ ನಿಮ್ಮ ಜಜ್ಮೆಂಟ್ ರೈಟಿಂಗ್ ಮೇಲೆ ಸ್ಪೆಷಲ್ ಫೋಕಸ್ ಆಗಿರುತ್ತೆ. ಸೊ ಇದಿಷ್ಟು ಓನ್ಲಿ ಫಾರ್ 12,000 rupees. ಆ್ಯಂಡ್ ಆಲ್ರೆಡಿ ನೀವು ನೋಡಿದ್ದೀರಿ ದಟ್ ಯಾವುದೇ ರೀತಿ ನಮ್ಮ ಬ್ಯಾಚಸ್ ಮನಿ ಮೈಂಡೆಡ್ ಆಗಿರೋವಂಥದ್ದಲ್ಲ. ಸೊ ಹಾಗಾಗಿ ನಾವು ಸರ್ವಿಸ್ ಓರಿಯೆಂಟೆಡ್ ಆಗಿ ನಿಮಗೆ ಲೆಕ್ಚರ್ಸ್ನ ಡೆಲಿವರ್ ಮಾಡ್ತಿದ್ದೀವಿ. ಆ್ಯಂಡ್ ಪ್ರತಿ ಒಂದು ಬ್ಯಾಚ್ ಮೇಲೆ ನನ್ನ 100% ಫೋಕಸ್ ಇರುತ್ತೆ. ಹಾಗೆಯೇ ನೀವು ಆಲ್ರೆಡಿ ನನ್ನ ಒಂದು ಫೀಡ್ಬ್ಯಾಕ್ ಸೀರೀಸ್ ಆಗಿರ್ಬೋದು, ಇಲ್ಲ ನನ್ನ ಒಂದು ವಿಡಿಯೋಸ್ ಮುಖಾಂತರ ನಿಮಗೆ ಗೊತ್ತಾಗೇ ಇರುತ್ತೆ ಈಗಾಗಲೇ ದಟ್ ನಾವು ಡೆಡಿಕೇಟೆಡ್ ಆಗಿ ನಿಮಗೆ ಓದಿಸೋದಕ್ಕೆ, ತಿಳಿಸೋದಕ್ಕೆ, ಕಮ್ಯುನಿಟಿ ಒಂದು ಬಿಲ್ಡ್ ಮಾಡಬೇಕು, ಒಂದು ಹೆಲ್ದಿ ಕಮ್ಯುನಿಟಿ, ಒಂದು ಹೆಲ್ದಿ ಸ್ಟೂಡೆಂಟ್ಸ್ ಕಾಂಪಿಟೇಷನ್ ಇರೋಂಥ ಒಂದು ಇದಕ್ಕೋಸ್ಕರ ನಾವು ಮಾಡ್ತಿರೋವಂಥದ್ದು. ಸೊ ಹಾಗಾಗಿ ಕಂಪ್ಲೀಟ್ ಸರ್ವಿಸ್ ಓರಿಯೆಂಟೆಡ್ ಆಗಿರುತ್ತೆ. ಆ್ಯಂಡ್ ಈ 12,000 rupees ತುಂಬ ನಾಮಿನಲ್ ಫೀಸ್. ಯಾವುದೇ ಒಂದು ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಇಲ್ಲ ಎಡ್ಟೆಕ್ ಕಂಪ್ನಿಗೆ ಕಂಪೇರ್ ಮಾಡಿದ್ರೆ ಅದರಲ್ಲಿ ಕಾಲ್ ಭಾಗದಷ್ಟು ಇಲ್ಲದೆ ಇರೋವಂಥದ್ದು. ಸೊ ಹಾಗಾಗಿ ನಿಮಗೆ ಯಾವುದೇ ರೀತಿ ಫೈನಾನ್ಷಿಯಲ್ ಬರ್ಡನ್ ಇಲ್ಲದೆ ಈ ಒಂದು ಬ್ಯಾಚ್ನ ನೀವು ಆರಾಮಾಗಿ ಎನ್ರೋಲ್ ಆಗಬಹುದು. ಸೊ ಇಲ್ಲಿಂದ ನಿಮಗೆ ಮೇನ್ಸಿಗೆ ಖಂಡಿತ ನಿಮ್ಮ ಒಂದು ಸಕ್ಸಸ್ಸನ್ನು ನಾವು ಎನ್ಶ್ಯೂರ್ ಮಾಡುವಂಥ ಪ್ರಯತ್ನ ನಮ್ಮದಾಗಿರುತ್ತೆ. ಸೊ ದಿಸ್ ಈಸ್ ಆಲ್ ಫಾರ್ ಯೋರ್ ನ್ಯೂ ಅಪ್ಕಮಿಂಗ್ ಮೇನ್ಸ್ ಬ್ಯಾಚ್. ಇಂಟ್ರೆಸ್ಟ್ ಇರೋವಂಥ ಪ್ರತಿಯೊಬ್ಬರು ಪ್ರಿಲಿಮ್ಸ್ ಪಾಸ್ ಆದ ನಂತರ ನೀವು ಎನ್ರೋಲ್ ಆಗೋದಕ್ಕೂ ತನಗೆ ತೊಂದರೆ ಇಲ್ಲ. ಈಗಲಿಂದನೇ ಎನ್ರೋಲ್ ಆಗ್ತಿರೋವಂಥ ಸ್ಟೂಡೆಂಟ್ಸ್ ತುಂಬ ಒಳ್ಳೆಯದು. ಸೊ ಆಲ್ ದ ವೆರಿ ಬೆಸ್ಟ್. ಆ್ಯಂಡ್ ಹಾಗೆಯೇ ವೀಕೆಂಡ್ ಬ್ಯಾಚಸ್ಗೂ ಸಹ ತುಂಬ ಕ್ವೆರೀಸ್ ಬರ್ತಿದೆ. ವೀಕೆಂಡ್ ಬ್ಯಾಚಸ್ಗೂ ಸಹ ಅಡ್ಮಿಷನ್ಸ್ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ. ಸೊ ಇಫ್ ಎಟ್ ಆಲ್ ನೀವು ವರ್ಕಿಂಗ್ ಇಂಡಿವಿಜುವಲ್ಸ್ ಆಗಿದ್ದಲ್ಲಿ ವೀಕೆಂಡ್ ಬ್ಯಾಚಸ್ಗೂ ಎನ್ರೋಲ್ ಆಗ್ಬೋದು. ಸ್ಯಾಟರ್ಡೇ ಆ್ಯಂಡ್ ಸಂಡೇ ನಿಮಗೆ ಕ್ಲಾಸ್ ನಡೆಯುತ್ತೆ ವೀಕೆಂಡ್ ಬ್ಯಾಚಸಲ್ಲಿ. ಅದಕ್ಕೂ ಎನ್ರೋಲ್ಮೆಂಟ್ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ, ಅಡ್ಮಿಷನ್ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ. ಸೊ ಇಫ್ ಎಟ್ ಆಲ್ ಯು ಆರ್ ಇಂಟ್ರೆಸ್ಟೆಡ್ ನೀವು ವೀಕೆಂಡ್ ಬ್ಯಾಚಸ್ಗೂ ಎನ್ರೋಲ್ ಆಗಬಹುದು. ವೀಕೆಂಡ್ ಬ್ಯಾಚಸಲ್ಲಿ ಪ್ರಿಲಿಮ್ಸ್, ಮೇನ್ಸ್, ಇಂಟರ್ವ್ಯೂ ಮೂರಕ್ಕೂ ಸಹ ನಿಮಗೆ ಗೈಡೆನ್ಸ್ ಸಿಗುತ್ತೆ ಇನ್ ಯೋರ್ ವೀಕೆಂಡ್ ಬ್ಯಾಚಸ್. ನಿಮಗೆ ಏನೇ ಕ್ವೆರೀಸ್ ಇದ್ದಲ್ಲಿ ಈ ನಂಬರ್ 9650849915 ಇದಕ್ಕೆ ನೀವು ವಾಟ್ಸಪ್ ಮಾಡಬಹುದು. ವಾಟ್ಸಪ್ ಮುಖಾಂತರ ಡೌಟ್ಸ್ನ ಕೇಳಬಹುದು, ಇಲ್ಲ ಕಾಲ್ ಮಾಡಬಹುದು. ಸೊ ಇನ್ನು ವಿಡಿಯೋನ ಸ್ಟಾರ್ಟ್ ಮಾಡೋಣ, ಮಾಕ್ ಟೆಸ್ಟ್ ವಿಡಿಯೋ. ಆ್ಯಂಡ್ ನಿಮ್ಮ ಪ್ರಿಲಿಮ್ಸ್ ಇನ್ನೇನು ಹತ್ತಿರದಲ್ಲೇ ಇದೆ. ಸೊ ಅದಕ್ಕೆ ಆಲ್ ದ ವೆರಿ ಬೆಸ್ಟ್. ಆದಷ್ಟು ಜಾಸ್ತಿ ರಿವೈಸ್ ಮಾಡಿ. ಆ್ಯಂಡ್ ಯಾವುದೇ ಒಂದು ಕಾರಣಕ್ಕೂ ಸಹ ಪ್ರಿಲಿಮ್ಸ್ ಎಕ್ಸಾಮ್ನ ತುಂಬ ಪ್ರೆಷರಲ್ಲಿ ಹ್ಯಾಂಡಲ್ ಮಾಡೋದಕ್ಕೆ ಆಗದೆ ಇರೋವಂಥ ಒಂದು ಇದರಲ್ಲಿ ಅನ್ಈಸಿನೆಸ್ಸಲ್ಲಿ ಬರೆಯೋದಕ್ಕೆ ಹೋಗಬೇಡಿ. ತುಂಬ ಕಾಮ್ ಆ್ಯಂಡ್ ಪೀಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಮೈಂಡಲ್ಲಿ ಪ್ರಿಲಿಮ್ಸ್ನ ಅಟೆಂಡ್ ಮಾಡಿ, ತುಂಬ ಒಳ್ಳೆ ರಿಸಲ್ಟ್ಸ್ ಬರುತ್ತೆ. ವಿಡಿಯೋ ಸ್ಟಾರ್ಟ್ ಮಾಡೋಣ. ಎವಿಡೆನ್ಸ್ ಆ್ಯಕ್ಟ್ ವಿಡಿಯೋ ಕಂಪ್ಲೀಟ್ ಆಗಿ ನೋಡಿ 100 questions ತನಕ. ಕ್ವೆಶನ್ ನಂಬರ್ 1. The Indian Evidence Act 1872 seeks to amend the law of evidence, define the law of evidence, consolidate the law of evidence, all of the above. Correct answer ಇಲ್ಲಿ all of the above. ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ? ಇಂಡಿಯನ್ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ನ ಪ್ರಿಯಾಂಬಲ್ ಪೋರ್ಷನ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. That Indian Evidence Act seeks to achieve amendment of law of evidence, define the law of evidence and consolidate the law of evidence ಅನ್ನೋದು. Next question number 2. The Indian Evidence Act was passed on. So Indian Evidence Act na pass ಮಾಡಿದ್ದು 5th March 1872 and ಅದು ಎನ್ಫೋರ್ಸ್ ಆಯಿತು 1st September 1872. ಪ್ರತಿಯೊಂದು ಆಕ್ಟ್ನ ನಿಮಗೆ ಎನ್ಫೋರ್ಸ್ಮೆಂಟ್ ಡೇಟ್ ಇಂಪಾರ್ಟೆಂಟ್ ಆಗುತ್ತೆ. ಪ್ರತಿಯೊಂದು ಆಕ್ಟ್ನ ಎನ್ಫೋರ್ಸ್ಮೆಂಟ್ ಡೇಟನ್ನು ತಿಳ್ಕೊಳ್ಳಿ. Question number 3. Indian Evidence Act applies to all judicial proceedings before court, all court martial no, but not to European court-martial. Arbitrators empowered to pass an award under the Arbitration and Conciliation Act. Affidavits presented to any court or officer. ಇದರಲ್ಲಿ ನಿಮಗೆ ಕರೆಕ್ಟ್ ಕೋಡ್ ಬಂದು ಆಪ್ಷನ್ ಬಿ, ಓನ್ಲಿ 1 and 2. All judicial proceedings before any court and Indian court-martial but not to European court-martial. Question number 4. The law of evidence is adjective law and it's also called as lex fori. So idu lex fori and it's adjective law. Question number 5. Evidence means and includes. So evidence means and includes statements made before the court, all documents produced for the inspection of the court, documents produced for the inspection of the court, excluding electronic records. Illa, idu including electronic records. So correct answer illi nimge option D, both A and C. Question number 6. In relation to Indian Evidence Act, which one of the following statement is not correct? ಇದರಲ್ಲಿ ಯಾವುದು ತಪ್ಪಾಗಿರುವಂಥ ಸ್ಟೇಟ್ಮೆಂಟ್? ಕೋರ್ಟ್ ಇನ್ಕ್ಲೂಡ್ ಆರ್ಬಿಟ್ರೇಟರ್ಸ್. ನೋ, ದಿಸ್ ಇಸ್ ನಾಟ್ ಕರೆಕ್ಟ್. ಸೊ ಇಲ್ಲಿ ಇದೇನೇ ರಾಂಗ್. ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಕೋರ್ಟ್ ಇನ್ಕ್ಲೂಡ್ಸ್ ಏನು ಆರ್ಬಿಟ್ರೇಟರ್ಸ್ ಅಲ್ಲ ಅನ್ನೋದು? ಇಟ್ಸ್ ಗಿವನ್ ಇನ್ ಯೋರ್ ಸೆಕ್ಷನ್ 1 of your Evidence Act. Question number 7. Under the Indian Evidence Act, which of the following is correct? Fact is mother and fact in issue is child. Fact in issue is also known as factum probandum, that which is to be proved. Words printed, lithographed or photographed are documents. A relevant fact is also known as factum probans, a fact that proves. ಇಲ್ಲಿ ಕರೆಕ್ಟ್ ಆನ್ಸರ್ ಬಂದು ನಿಮಗೆ ಆಪ್ಷನ್ ಎ, ಆಲ್ ಆರ್ ಕರೆಕ್ಟ್. ಕೊಟ್ಟಿರುವಂಥ ಎಲ್ಲ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಕರೆಕ್ಟ್. ಇದು ಇಂಪಾರ್ಟೆಂಟ್ ಆಗುತ್ತೆ. ಫ್ಯಾಕ್ಟಮ್ ಪ್ರೊಬ್ಯಾಂಡಮ್ ಆ್ಯಂಡ್ ಫ್ಯಾಕ್ಟಮ್ ಪ್ರೊಬ್ಯಾನ್ಸ್. ಫ್ಯಾಕ್ಟಮ್ ಪ್ರೊಬ್ಯಾಂಡಮ್ ಅಂದರೆ ದ ಫ್ಯಾಕ್ಟ್ ವಿಚ್ ಈಸ್ ಟು ಬಿ ಪ್ರೂವ್ಡ್ ಅಂದರೆ ಫ್ಯಾಕ್ಟ್ ಇನ್ ಇಶ್ಯೂ, ಆ್ಯಂಡ್ ರಿಲೆವೆಂಟ್ ಫ್ಯಾಕ್ಟ್ ಅಂದರೆ ಫ್ಯಾಕ್ಟಮ್ ಪ್ರೊಬ್ಯಾನ್ಸ್. ದ ಫ್ಯಾಕ್ಟ್ ವಿಚ್ ಪ್ರೂವ್ಸ್, ದ ಫ್ಯಾಕ್ಟ್ ವಿಚ್ ಇಸ್ ಯೂಸ್ ಟು ಪ್ರೂವ್ ಸಚ್ ಫ್ಯಾಕ್ಟ್ ಇನ್ ಇಶ್ಯೂ is called as factum probans. Question number 8. Document as defined in section 3 of Indian Evidence Act includes. Document includes a written document, plain paper, musical note, banner with an inscription. Question number 8 ಗೆ correct answer 1, 3 and 4. ಯಾಕೆಂದ್ರೆ plain paper ಯಾವ ರೀತಿಯಾದಂಥ document ಅಲ್ಲ. Question number 9. Consider the following statements regarding the Indian Evidence Act 1872. There are total 165 sections. Act is divided into 3 parts. There are 11 chapters in total. Which of the following is correct? Question number 9 the correct answer is option C. 2 and 3 are correct. Question number 10. Conclusive proof under the Indian Evidence Act implies. Conclusive proof implies that the court shall on the proof of one fact regard the other as proved and not allow further evidence to disprove it. Question number 11. Fact in issue is. Fact in issue is a disputed fact. Question number 12. Confession is. Confession is not defined in your Evidence Act. Confession and Evidence Act ಅಲ್ಲಿ as such ನಾವು define ಮಾಡಿಲ್ಲ. Admissions define ಆಗಿದೆ, but confession define ಆಗಿಲ್ಲ. Question number 13. Evidence can be given of existence of fact in issue or relevant fact, non-existence of fact in issue, non-existence of an issue of fact or relevant fact, non-existence of a fact in issue or relevant fact. Option D, both A and C. Correct answer really option D, both A and C. ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮಗಿದು question section 5 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. Section number 5. Question number 14. Affidavits are specially excluded by the Evidence Act because affidavits are excluded by Evidence Act because there may be statements in it based on information and belief. Question number 15. Confessions by the accused may be given due to due consideration. Confession of the accused may be given due consideration if they are tried jointly, if they are tried for same offense, If the confession is legally proved, all of the above, ಎಲ್ಲ statements correct. This is about your confession of co-accused. Question number 16. The committing magistrate is, ಯಾರು committing magistrate ಆಗ್ತಾರೆ? A court but not a judge. This is given in your section 3. Question number 17. Which is the main principle that underlies the law of evidence? Main principle that underlines law of evidence. Evidence must be confined to relevant fact. Hearsay evidence must not be discarded by the court at all times. Circumstantial evidence must be admitted at all times. The best evidence must be given in all cases. Correct answer is option D, 17. The best evidence must be given in all cases. Question number 18. The principle of res justae is, principle of res justae ನಿಮ್ಗೆ ಎಲ್ಲಿ ಸಿಗುತ್ತೆ? section 6 ಅಲ್ಲಿ ಸಿಗುತ್ತೆ. section 6, an English doctrine, a Roman doctrine, an Italian origin. It's both English doctrine and an Italian origin. Question number 19. A person is in his room and he hears his servant crying out that A is killing B. When the person rushes out to B, is unconscious and A has ran away from the scene. But his servant and others tell him what happened. He would inform the police who would investigate and finally bring A to trial for the murder of B. At the trial, the evidence of the person who heard the cry would be, so relevant fact, admissible as evidence, relevant though hearsay evidence. Correct answer option C, it is relevant though it is hearsay evidence. Question number 20. Which among the following do not form part of res justae? Which does not form part of res justae? Res justae, this is about your section 6. Now ಮಾತನಾಡ್ತಿರೋದು ಇನ್ನೂನು. The act of assailant intruding into the courtyard at the dead of night, the victim's identification of the assailant, her statement that the appellant was standing with a gun and that he fired at her. None of the above. Which does not form part of res justae andre option D, none of the above. ಎಲ್ಲಾನು ಸಹ res justae ಗೆ ಇನ್ವಾಲ್ವ್ ಆಗುತ್ತೆ. ಅಂದರೆ ಫ್ಯಾಕ್ಟ್ಸ್ ಫಾರ್ಮಿಂಗ್ ಪಾರ್ಟ್ ಆಫ್ ಸೇಮ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್. ಸೆಕ್ಷನ್ 6 ಹೇಳುತ್ತೆ ಫ್ಯಾಕ್ಟ್ಸ್ ಫಾರ್ಮಿಂಗ್ ಪಾರ್ಟ್ ಆಫ್ ಸೇಮ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್. ಸೊ ದೀಸ್ ಆರ್ ಆಲ್ included in your res justae. Question number 21. In which of the following cases it was held that contemporaneous dialogue formed part of res justae and is relevant and admissible under section 6 of Indian Evidence Act? ಇದನ್ನ ಹೆಲ್ಡ್ ಮಾಡಿದಂಥ ಕೇಸ್ ಬಂದು ಯೂಸಫ್ ಅಲಿ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಮಹಾರಾಷ್ಟ್ರ. ಸೆಕ್ಷನ್ 6ಗೆ ಲೀಡಿಂಗ್ ಕೇಸ್. ಕ್ವೆಶ್ಚನ್ ನಂಬರ್ 22. Doctrine of res justae is applicable to. So doctrine of res justae is applicable to civil as well as criminal proceedings. Question number 23. In which of the following cases it was held that the words so spoken should be de recenti and not after an interval in order to constitute res justae? Question number 23. Correct answer is R versus Christie. Question number 24. Which of the following are methods of proving handwriting? ಹ್ಯಾಂಡ್ ಪ್ರೂವ್ ಮಾಡೋದಕ್ಕೆ ಇರುವಂಥ ಯಾವುದೆಲ್ಲ ಮೆಥಡ್ಸ್ನ ಯೂಸ್ ಮಾಡ್ತೀವಿ? ಕ್ವೆಶ್ಚನ್ ನಂಬರ್ 24ಗೆ A. By calling the person who wrote the document, section 67 correct. By handwriting expert, section 45 opinion of an expert. By any previous admission by the person who had written it, section 21 correct answer option D, all of the above. Witness can refresh his memory. Witness can refresh his memory, section 159 allide. So adra sambandhapಟ್ಟ ಹಾಗೆ question from contemporaneous notes made by him under section 159, from records kept by him as part of his duty, section 34 to 35, both A and B, and none of the above. Question number 25 correct answer is option C, both A and B. Question number 26. Which provision of Indian Evidence Act contemplates real evidence? Real evidence is given in proviso to section 60. Question number 27. The central idea of R versus Bedingfield is, central idea of R versus Bedingfield antandre it was about spontaneity and contemporaneity of are the factors of res gestae. Question number 28. It is therefore that for describing the concept of res gestae, one would need to examine whether the fact is such as contemporaneously arising out of the occurrence, exclamations of hurt seeking help, of disbelieving, of caution, and the like, arising out of fact, spontaneous reactions to a fact, in the like. In which of the following cases it was held? ಇದನ್ನ ಹೆಲ್ಡ್ ಮಾಡಿದ್ದು ಯಾವ ಕೇಸಲ್ಲಿ? ಇನ್ ಸ್ಟೇಟ್ ಆಫ್ ಮಹಾರಾಷ್ಟ್ರ ವರ್ಸಸ್ ಕಮಲ್ ಅಹ್ಮದ್ ಖಾನ್, ವಕೀಲ್ ಅನ್ಸಾರಿ, 2013 case law. Question number 29. Facts in issue are. Facts in issue are an answer to the issue of fact. Facts which are alleged by one party and denied by the other party are fact in issue. C. Facts which are alleged by prosecution and denied by the accused. Correct. Option D, all of the above. Correct answer. Question number 30. A files a suit against B for recovering money due on a promissory note. B denies the execution of the note and also that A lent him any money. The issue of the fact in the said case are. The issue of the fact in the said case are. Did A lend money to B? Did B execute the promissory note? C. That B is liable to repay the principal amount and the interest calculated at a certain rate. Both A and B. Correct answer is option A and B. Now ಮಾತನಾಡ್ತಿರೋದು issues, fact in issue ಬಗ್ಗೆ, so ಹಾಗಾಗಿ option D is the correct answer. Question number 31. In case of a document being used as evidence in the Indian law, only recognizes writing and not material. Not only writing but also material. C. The definition of the document under the Indian Evidence Act is identical to the definition of document given in IPC and General Clauses Act. Correct answer ನಿಮಗೆ option D ಆಗುತ್ತೆ, both A and C. Section 3 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಇದನ್ನ. Question number 32. Is writing obtained by the court for the accused for comparison and evidence under the Indian Evidence Act? Correct answer is no. Section 73 prakara it is not a evidence under Indian Evidence Act. Question number 33. Relationship is not a factor to affect the credibility of the witness in the cases of. Relationship is not a factor to affect credibility of witness in the case of. Option interested witness. Question number 34. Which of the following is the best evidence? So, ಇಲ್ಲಿ best evidence ಅಂದರೆ documentary evidence, direct evidence, primary evidence, all of the above. Every evidence is best evidence as given here. Question number 35. Which of the following cases laid down the law pertaining to circumstantial evidence? Circumstantial evidence is Hanumant Govind Nargunkar versus State of MP. Question number 36. Circumstantial evidence is weak evidence and if necessary requires corroboration. Correct. Presumptive evidence. Correct. Conviction can solely be based on circumstantial evidence. Correct answer really option D, all of the above. Question number 37. In a suit there is an issue whether a letter has been written by B. X, a handwriting expert, compares the genuine writing of the B with the letter in question and gives his opinion that both are identical. Can another expert Y be allowed to say that in the opinion of X the writings are identical? Yes. So correct answer really question number 37 is option B. No, since this would amount to hearsay evidence. Question number 38. An evidence is relevant. Question number 38. When if obtained illegally, B. Even if the obtained in the course of the search or seizure in violation of the provisions of CRPC. C. Such evidence should be excluded only where the accused had been lured into incriminating himself by deception after the commission of an offense. D. All of the above. Correct answer bandu all of the above. Question number 39. Which of the following is good evidence? So, good evidence is confession of an co-accused, approver's evidence, written statement of an accused person, none of the above. Correct answer is approver's evidence is good evidence. Question number 40. Probative force of the evidence implies force to induce the court to believe in the existence of the fact sought to be proved, to consider its existence so probable that a prudent man ought to act upon the supposition that it exists, either A or B, both A and B. Correct answer is option either A or B. Question number 41. Which of the following is true in respect of maxim falsus in uno, falsus in omnibus? Correct answer nimge option. If it is merely a rule of caution, this maxim does not occupy the status of law in India. It means that if a thing is false in respect of one, it must be taken to be false in respect of all. Correct answer is all of the above. Question number 42. Which of the following is an instance of the rebuttable presumption of law? Nothing is an offense which is done by a child under the age of 7 years. Burden of proving that the case of the accused comes within exceptions. Presumption as to the documents 30 years old. None of the above. Correct answer nimge option B. Burden of proving the case of the accused comes within exception. Question number 43. Which of the following is not true about the relevancy and the admissibility of the evidence under the Indian Evidence Act? Relevancy and admissibility are coextensive and interchangeable terms. Correct. Relevant means that which is logical, probative, while admissibility is not based on logic but on law and strict rules. In the Indian Evidence Act, the question of relevancy has been dealt under the section 6 to 55 of the admissibility, and 56 onwards, the facts that are allowed to be proved are called relevant facts when the admissibility is the means of the methods of proving the relevant facts. No. Correct answer really option A. 43 question option A right answer. Question number 44. If a case plaintiff filed a suit for injury received due to a defective staircase, the defendant was allowed to adduce evidence that 43,000 persons have passed from the stairs and none received injuries. Under which section of the Indian Evidence Act will the fact be relevant? Such fact be relevant under section A, section 7 of the Indian Evidence Act. Idu section 7 na illustration anne kelirodu. Question number 45. Which of the following constitutes the motive under the section 8 of Indian Evidence Act? The fact that the accused, section 8 motive ಬಗ್ಗೆ, the fact that the accused was the father of the child of which the deceased was pregnant at the time of her murder. B. The accused farmer was financially embarrassed, and to overcome his difficulties, he borrowed large sums of money from one of his friends one night after attending the races together. His friend came back to his hotel and died soon after the midnight under the circumstances which raised a suspicion that he had been poisoned. Question number C. In a case, certain lands were inherited by the deceased along with his brother, but the accused got them transferred into their names at the time of the incident. Criminal and revenue cases were pending between the accused and the deceased. All of the above. Question number 45. Correct answer nimge option D. All of the above. Question number 46. Which of the following is incorrect with respect to the conduct under section 8 of Indian Evidence Act? Conduct yaudu? It is incorrect with respect to conduct. The conduct must be in reference to the fact in issue or the facts relevant to them. Option B, it needs to be contemporaneous. C, a conduct if relevant if it influences or is influenced by a fact. Only those statements which accompany and explain acts other than the statements can be regarded as conduct. Correct answer, if it need to be contemporaneous. No. Question number 47. A is running out, besmeared with blood and crying helplessly to the people of the vicinity to save his life from B, who had wounded him and is about to beat more. The cries of A is The cries of A is a complaint under section 8. Question number 48. A leisurely walks down from the place with injuries on his person, and when intervened and asked by a bystander, he says that B has assaulted him. This would amount to a statement under section 8, which is inadmissible. Question number 49. Identification of which of the following is allowed under section 9. Identification section 9 ಅಲ್ಲಿ ನಮಗೆ identification of new facts, introduction of new facts ಬಗ್ಗೆ ಹೇಳ್ತೀವಿ. introduction portion ಅದರಲ್ಲಿ ನಮಗೆ test identification ಕೂಡ it's a part of it. So ಇದರಲ್ಲಿ question number 49, identification of accused, identification of victim, identification of arms and bullets, everything is included, all of the above. Question number 50. What is the evidentiary value of the identification of the accused by witness for the first time in court without being tested by a prior identification parade? So, without being tested by a prior identification parade, identification of accused in the court for the first time is reliable. Identification is a substantive piece of evidence without prior test identification parade. Identification of accused for the first time in the court is valueless. None of the above. Option C is the correct answer. Question number 51. In which of the following cases the court held that the failure to hold test identification parade was not fatal to the prosecution case? This was held in the case of Pammi versus State of MP. Question number 52. Which of the following is true? In case the eyewitness account if found to be credible and trustworthy, the medical opinion suggesting an alternative possibility is not conclusive. B. In case of conflict between ocular evidence and the medical evidence, ocular evidence shall be preferred to the medical evidence in case ocular evidence is acceptable, trustworthy and reliable. Option C, both A and B. Option D, none of the above. Correct answer nimge option C, both A and B. Question number 53. Which of the following cases held that quote identification is a good identification in the eyes of law and no straitjacket formula can be adopted? So idu identification ಬಗ್ಗೆ section 9 ಬಗ್ಗೆ ಇರುವಂತ leading case law Rajiv Kapoor versus State of Rajasthan 2012. Question number 54. Which of the following is correct regarding to test identification parade? Test identification parade section 9. Section 9 ನ ಒಂದು ಭಾಗ ಅಷ್ಟೇ ಟೆಸ್ಟ್ ಐಡೆಂಟಿಫಿಕೇಶನ್ ಪರೇಡ್. ಸೆಕ್ಷನ್ 9 ಅಂದ್ರೇನೆ ಟೆಸ್ಟ್ ಐಡೆಂಟಿಫಿಕೇಶನ್ ಪರೇಡ್ ಅಂತ ಅಲ್ಲ. ಸೊ ಅದೊಂದು ವ್ಯಾಸ್ಟ್ ಆಗಿರುವಂಥ ಸೆಕ್ಷನ್, ತುಂಬ ದೊಡ್ಡದಾಗಿರುವಂಥ ಸೆಕ್ಷನ್, ಅದರಲ್ಲೊಂದು ಭಾಗ ಅಷ್ಟೇ ಟೆಸ್ಟ್ ಐಡೆಂಟಿಫಿಕೇಶನ್ ಪರೇಡ್. There is no fixed time of TIP and there is no rule of number of identifying witness. It is for court to decide in facts and circumstances of the case and evidence on record whether to accept or reject evidence of the identification. TIP doesn't constitute evidence but can be used only for corroboration of statement in the court. D, all of the above. Correct answer nimge question number 54 is option D. All of the above are correct relating to TIP. Question number 55. Which of the following is an essential of conspiracy? Which is essential about conspiracy? Conspiracy is an agreement to do an unlawful act or lawful act by lawful means. It is a crime as well as a tort. The basis of this rule is an agency. All of the above. Correct answer is all of the above. ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮಗೆ section 10 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ about conspiracy. Question number 56. In the words in reference to their common intention under section 10 means, it means in reference to what at the time of statement was intended in the future. Question number 57. Burden of proving the plea of alibi lies on. Plea of alibi section 11, it lies on the person who sets it up. Question number 58. ಯಾರು ಅಲೇಜ್ ಮಾಡ್ತಿದ್ದಾರೆ that I was not present in that spot, ಆಕ್ಸಿಡೆಂಟ್ ಆದಂಥ ಜಾಗದಲ್ಲಿ ನಾನು ಇರಲಿಲ್ಲ ಅಂತ ಯಾರು ಹೇಳ್ತಾರೆ ಅದೇ ವ್ಯಕ್ತಿ ಮೇಲೆ ಬರ್ಡನ್ ಆಫ್ ಪ್ರೂಫ್ ಇರುತ್ತೆ to prove that he was elsewhere. Question number 58. What is the evidentiary value of alibi witness? Alibi witness na ಯಾರನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀರಿ ಅವರ ಒಂದು evidentiary value ಯಾವ ರೀತಿ ಇರುತ್ತೆ? It is alibi witness has greater evidentiary value, but very often a witness may not be in position to offer such cogent alibi evidence. ತುಂಬಾ ಒಳ್ಳೆ high evidentiary value of plea of alibi ಅಲ್ಲಿ ಕೊಡುವಂತ alibi ಕೊಡುವಂತ witness. Question number 59. Where the question is whether A committed the murder of B by administering the poison, the fact that B committed a suicide by consuming poison is relevant under section 11. It is relevant under section 11 of your Evidence Act. Question number 60. Which of the following is true about section 11? Section 11, the section is too wide in its import, correct? It does not place any restriction upon the range of facts that can be admitted as showing inconsistencies or probabilities. No finding of plea of alibi can be recorded by the High Court for the first time in a quotation under section 482 of CRPC. All of the above. Correct answer really all of the above are true regarding your plea of alibi. Question number 61. Section 12 applies to. Section 12 applies to civil cases, civil and tort, either A or B, both, none of the above. Correct answer is civil cases. ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮಗೆ section 12 ಅಲ್ಲೇನೆ ಕೊಟ್ಟಿದ್ದಾರೆ that it applies to civil cases. Question number 13 applies to. So question number 13 applies to all kinds of rights, all customs and usages, both A and B. Correct answer both A and B. Question number 63. Where the former judgment can operate as a transaction within the meaning of section 13. Section 13, where a former judgment can operate as transaction within the meaning of section 13. Correct answer is yes. Question number 64. Under section 614 in Evidence Act, evidence cannot be given. Under section 14, evidence cannot be given to prove the state of mind in general. Question number 65. Where the charge is that the intentional murder and robbery instances of other dacoities by the same person would be relevant under section 14, would not be relevant for they would not show an intention to cause the death of a particular person. Option C, either A or B. Option D, none of the above. Question number 65, correct answer is option B. Illustration in the ಕೇಳಿರುವಂತದ್ದು but would not be relevant for they would not show any intention to cause death of the particular person. Question number 66. Statement about one's own bodily feeling are of self-serving nature under section 21, self-harming nature. Option D, none of the above. Question number 66. Correct answer nimge option B, self-serving in nature under section 21. Question number 67. As a general rule, in order to prove that the accused is guilty of the theft, the evidence of past or subsequent theft committed by him are admissible only to the extent. It is only to the extent to show the state of mind of accused and not to prove the existence of the fact in issue, to overthrow the defense of the act in question being a mere accident. Option C, both A and B. Correct answer both A and B. Question number 68. Which of the following is true about section 15? Which of the following is true about section 15? The section covers only those cases where the question is whether a particular fact is accidental or intentional. This section is particular application of the general rule laid down in the previous section, both A and B, none of the above. Question number 68. Correct answer is your option C, both A and B. Question number 69. Presumption of court under section 16 is presumption of court. Section 16 ಅಲ್ಲಿ ಕೊಟ್ಟಿರುವಂತ presumption, it's about presumption is only permissible and not inevitable presumption. Question number 70. Which of the following is incorrect regarding admissions? Admissions ಬಗ್ಗೆ ಯಾವುದು ಸರಿಯಾದ ಆಪ್ಷನ್ ಅಲ್ಲ. Admission need not be addressed to any particular person. Admission made in a state of soliloquy are also provable. Admission can also be made by means of signs and gestures. None of the above. Signs and gestures, none of the above. Question number 70. Correct answer is option D. None of the above. ಯಾಕೆಂದ್ರೆ ಮೇಲೆ ಕೊಟ್ಟಿರುವಂತ ಮೂರು ಆಪ್ಷನ್ಸ್ ಸರಿಯಾದಂತ ಆಪ್ಷನ್ಸ್. ಅಡ್ಮಿಷನ್ ನೀಡ್ ನಾಟ್ ಬಿ ಅಡ್ರೆಸ್ ಟು ಎನಿ ಪರ್ಟಿಕ್ಯುಲರ್ ಪರ್ಸನ್. ಒಬ್ಬ ವ್ಯಕ್ತಿನ ತೋರಿಸಿ ಇಲ್ಲ ಆ ವ್ಯಕ್ತಿಯಿಂದನೇ ಆ ವ್ಯಕ್ತಿ ಪರ್ಟಿಕ್ಯುಲರ್ ಪರ್ಸನ್ ಇದರಲ್ಲೇನೆ ಹೇಳಬೇಕಂತ ಏನಿಲ್ಲ. ಅಡ್ಮಿಷನ್ಸ್ ನೀವು ನಿಮ್ಮಷ್ಟು ನೀವೇ ಏನಾದರೂ ಮಾತನಾಡ್ಕೊಳ್ಳೋದು ಸೋಲಿಕ್ವಿ ಈಸ್ ಆಲ್ಸೋ ಕರೆಕ್ಟ್. ಆ್ಯಂಡ್ ಅಡ್ಮಿಷನ್ ಸೈನ್ಸ್ ಆ್ಯಂಡ್ ಜೆಸ್ಚರ್ಸ್ ಅಂತಂದರೆ ಏನಾದರೂ ಸನ್ನೆ ಮಾಡೋದು ಕೂಡ ಸಹ ಅಡ್ಮಿಷನ್ಸ್ ಆಗತ್ತೆ. ಕ್ವೆಶ್ಚನ್ ನಂಬರ್ 71. ವಿಚ್ ಆಫ್ ದ ಫಾಲೋಯಿಂಗ್ ಆರ್ ಫಾರ್ಮಲ್ ಅಡ್ಮಿಷನ್ಸ್ ಆರ್ ಜುಡಿಷಿಯಲ್ ಅಡ್ಮಿಷನ್ಸ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ 58? Correct answer is option. Admissions are made in judicial proceeding. Admission made by parties in writing. Admissions deemed by any rule of pleading in force. Option D. All of the above are correct answers. Question number 72. Admission can operate as a waiver of the proof in the course of judicial proceedings. Only in case of formal admission. In case of formal and informal admission, either A or B. Only in case of formal admission but not in case of informal admission which are made casually. Correct answer is option D. Correct answer idu. ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮಗೆ admissions clauses section admissions clauses ಅಲ್ಲಿ. Question number 73. Admission is substantive evidence and is relevant, a substantive piece of evidence, a corroborative evidence, none of the above. Question number 73, option is A, a substantive evidence and is relevant. Question number 74. Which of the following may not be presumed by the court? Section 89 ನಿಮಗೆ ಇದರ ಆನ್ಸರ್ ಅನ್ನು ಹೇಳುತ್ತೆ. Which of the following cannot be presumed? Presumption as to telegraphic message, presumption as to electronic message, presumption as to due exception of the documents not produced, none of the above. Correct answer is your option C, presumption as to due exceptions, due execution of documents not produced. Question number 75. Which of the following is true with respect to admission made by a legal counsel? Admission made by a legal counsel ಬಗ್ಗೆ correct option ಯಾವುದು? Admission made by legal counsel is not binding on the client. No, it's binding. Admission made by the counsel on the matter of law or on an issue of the mixed question of law and fact are not binding on the party he represents. Admission made by the counsel is binding on the client whether provided it is related to the subject matter of the suit and made under a misapprehension. Correct answer nimge option D. Both A, B and C options are correct. Question number 76. Which of the following is related to ambiguity? Question number 76, option A, section 95 is related to ambiguity. Question number 77. Which of the following things fall out of purview of confession? Exculpatory evidence, exculpatory statement, guilty conduct, acknowledgement of subordinate facts, all of the above. Question number 77. Correct answer is all of the above. Confession must be taken as a whole or rejected as a whole, partially accepted or partially rejected, completely accepted or partially rejected, partially accepted or completely rejected. Question number 78. Confession must be taken as a whole or rejected as a whole. Confession comprises of, question number 79. Confession comprises of only inculpatory statements. Exculpatory statements na confession agi nododilla. Question number 80. Which of the following is correct with respect to confession? Which of the following is correct with respect to confession? A. Confession appears for the first time in section 24. Confession is merely on the basis of species of admission, where the admission is not direct or clear, but only an inference of guilt of the accused could be drawn from the admission. Such admission would not amount to confession. D. All of the above. Question number 80. Correct answer is your D, all of the above. Question number 81. R was charged with the murder of his wife and 3 daughters. He wrote on a piece of paper that they were not in this world. Correct answer. This will be an admission. It will be a confession. Neither A nor B. Option D, none of the above. Correct answer is A. This will be an admission. Question number 82. M and K were threatened in a panchayat of their caste fellows that they would be excommunicated and cast from the caste for life if they do not tell whether they murdered B. Upon this, they confess the guilt. Will the confession be admissible as the evidence? Question number 82. Correct answer is your option C. The confession will be admissible under section 24 as there was no threat made having in reference to any charge against them. Question number 83. Section 24 applies to. Section 24 applies to a person who was not an accused at the time when he made the confession but was charged with the offense at a later stage. Question number 84. It is a general principle that the confession must be accepted as a whole. The exception to the above principle is it is permissible to believe that one part of the confessional statement which is inculpatory if there is other evidence on record to prove its correctness. B. If the exculpatory part of the statement is inherently improbable, it may be rejected and inculpatory part may be admitted. C. Both A and B. Correct answer is okay. Option C. Both A and B. Question number 85. Which is untrue with respect to evidentiary value of confession? Yaudu tappu. Accused can be convicted solely on the basis of confession made to the magistrate. Extrajudicial confession need no corroboration. Correct answer idu. Extrajudicial confession needs corroboration. Judicial confession ge it needs no corroboration ಅನ್ನೋದು correct statement. C. Extrajudicial confession a weak piece of evidence and can be relied upon only when it is clear, consistent and convincing. So option B ili tappu. So hagagi option B would be the right answer. Question number 86. Which of the following cases deal with delay in retraction of confession? Question number 86. Correct answer is your option B. Sanjay Dutt versus State of Maharashtra, Muhammad Amin versus CBI. Question number 87. Which section deals with confession to the police officer? It applies to section 25. Confession to police officer applies to confession made before investigation, confession made after investigation, both confession made before investigation and confession made after investigation. D. None of the above. Question number 87. Correct answer is your option C. Both confession made before and after investigation. Question number 88. The prohibition of section 25 applies to only confession which are to be proved against the accused in support of prosecution case, only to statement on which the accused himself wishes to rely for his defense, either A or B, none of the above. So question number 88, correct answer is your A. Only confession which are to be proved against the accused in support of prosecution case. Question number 89. Several persons of one party drove several cattle belonging to the deceased to the cattle pond. Two of them made a statement to the police that the cattle of the deceased damaged their crops while they were bringing the cattle to the pond. The deceased interfered with the carrying of the cattle and so there was a fight which caused death of the deceased. The statement of the police was not admissible in the evidence as it was a mere complaint and not an admission of the guilt. It was admissible as the evidence of confession was only an exculpatory statement two of the circumstances under which the cattle had been seized, both A and C. Question number 89, correct answer ನಿಮಗೆ option D, both A and C. Question number 90, custody of police under section 26 implies. Custody of police implies direct or indirect police surveillance, restriction on the movements of the accused. Correct answer both A and B. Question number 91. The admission of the accused before custom authorities is not covered by section 25, is covered by section 25, is not covered by either section 25 or 26. None of the above. Correct answer is option C. It is not covered either by section 25 or 26. Question number 92. If A is charged under section 325 of IPC for having caused grievous injury to B, but C is charged under section 325 for having caused grievous injury to G, and then suppose A and C are tried jointly, the confession of A against C would be admissible as evidence, would not be admissible as the evidence because they are not being tried for the identical offense, would not be admissible under section 30, both B and C. Question number 92, the correct answer is option D, both B and C are correct. Question number 93. Which of the following is true with respect to the relevancy of judgments? As a matter of general principle, the judgment of the previous case is not relevant in another case. Exceptions have been provided in section 40 to 42. If a judgment is not relevant under section 40 to 42, then it will not be relevant under any other provision of the Evidence Act. D, all of the above. Question number 93, correct option bandu all of the above. Section 40 to 42 alli koಟ್ಟಿರುವಂತ provisions. Question number 94, evidence of res judicata is admissible. Res judicata evidence is admissible under section 40 of the Indian Evidence Act. Question number 95, under section 41. Under section 41, the judgment in rem are relevant only for showing. The judgment in rem are relevant only for showing that the judgment confers a legal character on a person, that it has declared that a person had such legal character, that it has declared that any legal character of the person which subsisted had ceased to exist. Option D, all of the above. Question number 95, correct answer is your option D. All of the above are correct. Question number 96, new facts can be introduced at the stage of. Question number 96, new facts can be introduced at the stage of cross-examination. ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ section 138 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ that it can be introduced in your cross-examination. Question number 97, which of the following is indicative in nature? Which is an indicative in nature? So, leading questions are indicative in nature. It's given in your section 141, leading questions. Question number 98, leading questions may be asked whether they are not objected to by the opposite party or were objected but overruled by the court, may always be asked in cross-examination, matter of disputed or introductory nature, or the matter in question has already been satisfactorily proved, where they deal with the matter of undisputed or introductory nature, or the matter in question has already been satisfactorily proved. Option D, all of the above. So, question number 98, correct answer is your option D, all of the above. ಮೇಲೆ ಕೊಟ್ಟಿರುವಂತ ಅಷ್ಟು ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಕರೆಕ್ಟ್ ಆಗಿರುವಂತ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್. ಇದನ್ನ ಕೊಟ್ಟಿರೋದು ಸೆಕ್ಷನ್ 142 ಹಾಗೂ 143 ಅಲ್ಲಿ ಕೊಟ್ಟಿರುವಂತ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಇದು. Question number 99, which section of the Indian Evidence Act permits cross-examination by oral statements? Section 153 permit ಮಾಡುತ್ತೆ, so it's option C. Question number 100, is section 145 attracted in the case of admissions? So section 145 is not attracted in cases of admissions. ಇಲ್ಲಿಗೆ ನಮ್ಮ 100 questions of your Evidence Act ಮುಗಿಯುತ್ತೆ. ಆ್ಯಂಡ್ ಇದು ಕಂಪ್ಲೀಟ್ 1 to 100 ಎಲ್ಲ ಕ್ವೆಶನ್ಸ್ ನಿಮಗೆ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ ಆಗಿತ್ತು, ಸಬ್ಜೆಕ್ಟ್ ಸ್ಪೆಸಿಫಿಕ್ ಮಾಕ್ ಟೆಸ್ಟ್ ಆ್ಯಂಡ್ ಇಂಪಾರ್ಟೆಂಟ್ ಆಗಿರುವಂಥ ಕ್ವೆಶನ್ಸ್ ಬೇಸ್ಡ್ ಆನ್ ಯೋರ್ ಸೆಕ್ಷನ್ ಬೇಸ್ಡ್ ಕ್ವೆಶನ್ಸ್ ಅನ್ನೇ ಕೇಳೋದು. ಸೊ ಹಾಗಾಗಿ ಬಿ ಪ್ರಿಪೇರ್ಡ್ ವಿತ್ ಯೋರ್ ಬೇರ್ ಆಕ್ಟ್, ನಿಮ್ಮ ಸೆಕ್ಷನ್ಸ್ ಹಾಗೂ ಆ ಸೆಕ್ಷನ್ ಹೆಡ್ ಏನಿದೆ ಇದನ್ನು ಚೆನ್ನಾಗಿ ಪ್ರಿಪೇರ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಕೆಲವೊಂದು ಇಂಪಾರ್ಟೆಂಟ್ ಸೆಕ್ಷನ್ಸ್ ಏನಿದೆ ಅದರ ಒಂದು ಬೇಸಿಕ್ ಕಾನ್ಸೆಪ್ಟ್ ಏನು ಅನ್ನೋದು ಗೊತ್ತಿರಬೇಕಾಗುತ್ತೆ. ಸೊ ಇದಿಷ್ಟು ನಿಮಗೆ ಎವಿಡೆನ್ಸ್ ಆ್ಯಕ್ಟ್ಗೆ ಸಂಬಂಧಪಟ್ಟ ಹಾಗೆ ಇದ್ದಂಥ ಕ್ವೆಶನ್ಸ್. ಇನ್ನೇನಾದರೂ ನಿಮಗೆ ಕ್ವೆರಿ ಇದ್ದಲ್ಲಿ, ನಿಮಗೆ ಡೌಟ್ಸ್ ಇದ್ದಲ್ಲಿ ನೀವು ಕಮೆಂಟ್ ಸೆಕ್ಷನ್ ಮುಖಾಂತರ ಕೇಳ್ಬೋದು. ಆ್ಯಂಡ್ ವಿಡಿಯೋ ಇಷ್ಟ ಆದಲ್ಲಿ ಲೈಕ್ ಮಾಡಿ, ಶೇರ್ ಮಾಡಿ ಆದಷ್ಟು ಜನರ ಜೊತೆ, ನಿಮ್ಮ ಫ್ರೆಂಡ್ಸ್ ಜೊತೆ. ಆ್ಯಂಡ್ ಯಾರಾದರೂ ನಿಮ್ಮ ಫ್ಯಾಮಿಲಿಯಲ್ಲಿ ಎಕ್ಸಾಮ್ ತಗೊಳ್ತಿದ್ದಾರೆ ಅಂತಂದರೆ ಅವ್ರಿಗೂ ಸಹ ವೀಡಿಯೋಸನ್ನು ಶೇರ್ ಮಾಡಿ. ಚಾನಲ್ನ ಸಬ್ಸ್ಕ್ರೈಬ್ ಮಾಡಿ, ಬಿಕಾಸ್ ನಿಮಗೆ ಎಷ್ಟು ನಾನು ಡೆಡಿಕೇಟೆಡ್ ಆಗಿ ವೀಡಿಯೋಸ್ನ ಪ್ರೊವೈಡ್ ಮಾಡ್ತಿದ್ದೀನಿ ಅಂತಂದರೆ ನೀವು ನನಗೋಸ್ಕರ ಒಂದು ಚಾನಲ್ ಸಬ್ಸ್ಕ್ರಿಪ್ಷನ್ ಇಲ್ಲ ಅಂತಂದರೆ ಒಂದು ಲೈಕನ್ನು ಖಂಡಿತ ಕೊಡ್ಬೋದು. ಸೊ ಇಲ್ಲಿ ತನಕ ಎಂಡ್ ತನಕ ವಿಡಿಯೋನ ನೋಡಿದ್ದೀರಿ ಅಂತಂದರೆ ಖಂಡಿತ ನಿಮಗೆ ವಿಡಿಯೋ ಯೂಸ್ಫುಲ್ ಆಗಿರುತ್ತೆ, ಇಷ್ಟ ಆಗಿರುತ್ತೆ. ಸೊ ಹಾಗಾಗಿ ನೋಡಿದ್ದೀರಿ. ಸೊ ಇಷ್ಟ ಆಗಿದೆ ಅಂತಂದರೆ ಒಂದು ಲೈಕ್ ಹಾಗೂ ಒಂದು ಸಬ್ಸ್ಕ್ರೈಬನ್ನು ಮಾಡಬಹುದು. ಆ್ಯಂಡ್ ನಮ್ಮ ಆಲ್ರೆಡಿ ಹೇಳ್ದಾಗೆ ಮೇನ್ಸ್ ಬ್ಯಾಚ್ ಅಡ್ಮಿಷನ್ಸ್ ನಡೀತಿದೆ. ಅಡ್ಮಿಷನ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಆದಷ್ಟು ಬೇಗ ಅಡ್ಮಿಷನ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಬಿಕಾಸ್ ಈ 10,000 rupees ಅರ್ಲಿ ಬರ್ಡ್ ಆಫರ್ ಮುಗಿಲಿದೆ. ಅದಾದ ನಂತರ ಫೀಸ್ ನಿಮಗೆ 12,000 rupees ಆಗುತ್ತೆ. ಸೊ ಹಾಗಾಗಿ ನೀವು ಆದಷ್ಟು ಬೇಗ ನಿಮ್ಮ ಒಂದು ಎನ್ರೋಲ್ಮೆಂಟನ್ನು ಮಾಡ್ಕೊಳ್ಳಿ ಮೇನ್ಸ್ ಬ್ಯಾಚ್ಗೆ. ಆ್ಯಂಡ್ ನಿಮ್ಮ ಪ್ರಿಲಿಮ್ಸ್ ಏನು ಇನ್ನೊಂದು 2-3 ದಿನದಲ್ಲಿದೆ, ಅದಕ್ಕೆ ಆಲ್ ದ ವೆರಿ ಬೆಸ್ಟ್. ಆದಷ್ಟು ಜಾಸ್ತಿ ನಿಮ್ಮ ರಿವಿಷನ್ ಮೇಲೆ ಫೋಕಸ್ ಮಾಡಿ. ಆ್ಯಂಡ್ ಆದಷ್ಟು ಜಾಸ್ತಿ ನೀವು ಆಲ್ರೆಡಿ ಏನು ಓದಿದ್ದೀರಿ ಅದನ್ನು ರಿವೈಸ್ ಮಾಡೋದ್ರ ಮೇಲೆ ಫೋಕಸ್ ಮಾಡಿ. ಸೊ ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್. ಆ್ಯಂಡ್ ಇದೇ ರೀತಿ ನಮಗೆ ಸಪೋರ್ಟ್ ಮಾಡ್ತೀರಿ. ಆ್ಯಂಡ್ ನಿಮ್ಮ ಒಂದು ಸಪೋರ್ಟೇ ನಮಗೆ ಸ್ಟ್ರೆಂತ್ ಅಂತ ಹೇಳ್ತಾ ಥ್ಯಾಂಕ್ ಯು. ನೆಕ್ಸ್ಟ್ ವಿಡಿಯೋಲಿ ಸಿಗೋಣ.